Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers the Fifth Amendment, reasonable suspicion, and stalking, and comes to us from Awakening the Masses channel. Be sure to check out the description below and give them the credit that they deserve. On June 5th, 2015, private investigator and First Amendment activist Michael Hoffman was working a case in Jacksonville, Florida that required him to conduct surveillance on an individual and follow her to several locations. After the target apparently called the police and accused Mr. Hoffman of stalking her, he was pulled over while driving by an officer with the Jacksonville Sheriff's Office.
Now we get to meet one another. How are you doing? What's going on with you following? Are you an investigator of some sort?
Can I ask why you pulled me over, sir?
I pulled you over because the young ladies came over there and said you've been following her since she left the airport yesterday. So I want to know who you are.
Have I committed a crime?
No, but I'm conducting an investigation. Have you been following that young lady? I mean, if you're an investigator, investigate away. But if you're somebody harassing her or stalking her, that's against the law. Me pulling you over to find out who you are is me doing my job.
Am I free to go?
No, you are not. Not until I find out who you are. I'm conducting an investigation. Do you have your driver's license, registration, and proof of insurance on you?
Have you pulled me for a traffic violation, sir?
No, sir. I've already explained that to you. Now, you can play the back and forth rigmarole all you want to. I've explained to you why I pulled you over.
Okay, and
The
you
young
didn't
lady
have
said that
PC. I'm not suspected of
The
committing a
probable
crime.
cause is that you've been following this young lady, and she.
Do you know that, sir?
Life.
Did you see that? Did you see that,
You
deputy?
came back by. Why'd you come back by?
I don't have to answer questions.
Okay, you don't have to answer questions. Okay, you do have to identify yourself.
Sir, if you suspect me of committing a crime or about to commit a crime, I have to identify myself. You have no probable cause to pull me for a traffic violation. I asked you why you pulled me.
Because the young lady said that you've been following her since yesterday.
So you believe everything everyone says to you?
Mr. Hoffman verbally announces that he was not going to speak without legal counsel present, invoking his Fifth Amendment privilege against self-incrimination. As we have discussed in previous episodes of ATA, simply remaining silent is not enough to claim the right to remain silent. Rather, individuals must affirmatively state that they are invoking their Fifth Amendment right. In the 2013 case of Salinas versus Texas, the Supreme Court held that, quote, "A suspect who stands mute has not done enough to put police on notice that he is relying on his Fifth Amendment privilege." The court additionally concluded that because the Fifth Amendment did not create an unqualified right to remain silent, a suspect's silence during questioning can be used against them as evidence of their guilt. After Mr. Hoffman invoked his Fifth Amendment rights, the officer told him to bring his legal counsel to the scene so that he could be questioned. However, officers cannot require citizens to produce legal counsel so they can question them during a Terry stop. As the Supreme Court explained in the 1984 case of Berkemer versus McCarty, during a Terry stop, quote, "The officer may ask the detainee a moderate number of questions to determine his identity and to try to obtain information confirming or dispelling the officer's suspicions. But the detainee is not obliged to respond, and unless the detainee's answers provide the officer with probable cause to arrest him, he must then be released." In fact, police officers typically cannot compel a citizen to answer their questions or cooperate with their investigations under any circumstances, even if the individual has been arrested and charged with a crime. A judge may order an individual to answer a question during a court proceeding, but even then, they can claim their Fifth Amendment privilege if they believe the answer may incriminate them. Therefore, Mr. Hoffman was completely within his rights to refuse to answer questions, and as long as there was no probable cause to make an arrest, Mr. Hoffman should have been released after a brief detention.
I'm conducting an investigation.
Okay. Will you conduct right away, sir? At this point in time, I elect to not say anything. I elect to speak to say anything without having my attorney present. That would be Eric Friday.
Call him. Tell him to come up here. We're at the 8100 block of Arlington Express.
I don't answer questions, Deputy.
You don't answer questions. You just stalk young ladies. Just stand by them. Stand by.
Your name and badge number, Deputy? Your name and badge number, Deputy?
Hey buddy, what's going on here?
Name and badge number, sir?
Simpson 66190.
Masinsin, M-A-S-I-N-S-I-N. Sir, I'd like to know why I'm being detained.
No, someone's saying that you're claiming you're stalking them. Are you an investigator or anything?
Okay, let me make this clear, sir. I would like for you to articulate what crime you suspect me of committing or what crime you suspect me of about to commit.
No, we just have a reasonable suspicion to figure out what's going on here.
No, sir. So you don't get to detain me to figure out if I've committed a crime, sir. The law and the statute states In order for you to detain me, you must have reasonable, articulable suspicion that either I have committed.
Yeah, we have probable cause.
What is your probable cause?
We got a complaint that we got that the red.
That's not probable cause, sir. What crime do you suspect me of committing?
Stalking.
Mr. Hoffman argues that the officers cannot detain him to figure out if he had committed a crime, and that they need a reasonable, articulable suspicion that he has committed or is about to commit a crime. Although officers are required to have reasonable suspicion in order to conduct a Terry stop, they do not need reasonable suspicion of a specific crime in order to satisfy the Fourth Amendment, and the primary purpose of a Terry stop is to investigate whether criminal activity is afoot. In the 2002 case of United States versus Arvizu, the Supreme Court explained that, quote, when discussing how reviewing courts should make reasonable suspicion determinations, we have said repeatedly that they must look at the totality of the circumstances of each case to see whether the detaining officer has a particularized and objective basis for suspecting legal wrongdoing. The court also concluded that, quote, a determination that reasonable suspicion exists need not rule out the possibility of innocent conduct, and that a stop can still be reasonable within the meaning of the Fourth Amendment if the detainee's conduct is susceptible to innocent explanation. In this situation, the police stopped Mr. Hoffman based on an accusation of stalking, and the fact that his vehicle allegedly matched the description of the vehicle that the subject of Mr. Hoffman's investigation reported as following her, which a court would likely conclude gave the officers reasonable suspicion to detain and investigate Mr. Hoffman. In the 1990 case of Alabama versus White, the Supreme Court held that an accusation, whether from a known informant or an anonymous source, can be sufficient to justify a Terry stop as long as the tip included sufficient, quote, indicia of reliability. The court explained that, quote, when significant aspects of the caller's predictions were verified, there was reason to believe not only that the caller was honest, but also that he was well informed, at least well enough to justify the stop. While we are not privy to all of the information the police had at their disposal when deciding whether to stop Mr. Hoffman, because the standard for reasonable suspicion is so low, a court would likely uphold this stop based on the information provided by the complainant and the corroborated description of the vehicle.
Your name and badge number, sir?
Sir, what's your name?
Your name and badge number, sir?
Are you gonna remember?
But all you're being recorded. I've got 4 cameras in this truck.
No,
You're required by policy to issue your name and badge number. I'm going to ask you what. I'm speaking to this gentleman right now. I'll get your name and badge number in a minute. Your name and badge number.
0051.
What's your name?
I just told you.
I didn't hear it because I'm sitting here speaking to this
recording
gentleman.
it so you can pick it up later.
So I'm going to ask you once again. If you want to be a smart about it, I'll file an internal affairs case on you.
I gave you once already.
I didn't hear it. I'm asking you once again. So to extend some professional courtesy and treat me with the respect I deserve.
I did.
What is your name and badge number?
Well, here's sir. I gave you mine. 0051.
Thank you. I appreciate that, Deputy. Was that so hard?
No.
The law states.
courtesy,
The
sir.
law states I don't have to give my name and information unless you suspect me of committing a crime.
I don't.
Then am I free to go? Because this
At
is
this
an
time.
illegal detainment.
At this time.
This is an illegal detainment.
Like I said, your criminal description we were given.
I respect
doesn't
that.
mean
I respect
you're guilty.
that. I respect that. You're
doesn't
talking
mean
to an
you're
ex-law
guilty.
enforcement officer here, buddy. Now, I understand you're doing no fault with that. You are doing your job.
Okay.
And the mere fact that I'm exercising my legal rights does not make me uncooperative. Okay? Now, the fact that someone called you and said they're harassing doesn't give you the general order just to stop people.
No, that wasn't the reason why. Because a person in a vehicle that matched your description was doing that. We didn't say you were doing it.
Okay.
And that's what we're coming down to.
But how do you define harassing? Someone just called and says they were
I
harassing.
didn't-
Did you ask her what they did? Did you ask the person?
Following.
She said a red truck, pickup truck was following her since she came to town.
Is that a crime?
The officers claim that the subject of Mr. Hoffman's investigation reported that a vehicle matching the description of his truck was following her, and Mr. Hoffman asks if that's a crime. According to Section 784.048 of the Florida statutes, quote, a person who willfully, maliciously, and repeatedly follows, harasses, or cyberstalks another person commits the offense of stalking, a misdemeanor of the first degree. The standard jury instructions for this statute explain that, quote, willfully means knowingly, intentionally, and purposely, and, quote, maliciously means wrongfully, intentionally, and without legal justification or excuse. In other words, following someone can be a crime in Florida, but only if it is repeated and intentional and there's no legitimate reason for doing so. According to Section 493.6101 of the Florida statutes, as a private investigator, Mr. Hoffman is licensed by the state and authorized to conduct investigations to obtain information about topics such as the identity, habits, conduct, movements, whereabouts, affiliations, associations, transactions, reputation, or character of any society, person, or group of persons, the credibility of witnesses or other persons, the whereabouts of missing persons, owners of unclaimed property, or heirs to estates, and the location or recovery of lost or stolen property. When he was following the individual who reported him to the police, Mr. Hoffman claims to have been investigating her for a domestic case, which would almost certainly fall under his authority to investigate the, quote, identity, habits, conduct, movements, whereabouts, affiliations, associations, transactions, reputation, or character of any person. Although private investigators are not permitted to commit crimes or otherwise break the law while conducting investigations, in this case, a court would likely conclude that Mr. Hoffman was not maliciously following the subject because his surveillance served a legal and legitimate purpose, which would mean that he could not be convicted under the Florida stalking statute. All that said, there is a high probability that Mr. Hoffman could have been lawfully charged with stalking if he wasn't a private investigator, and the Jacksonville deputies had no way of knowing that he was an investigator upon making contact with him.
We haven't determined that. We just want to make sure.
Do you see where I'm going with this, sir? I mean, I understand you guys are doing your job, but do you see how this goes? I'm aware of my rights. You do not have, or excuse me, you have the right to ask me whatever question you want.
You're really enjoying this.
I'm not enjoying anything. You know what I am enjoying? How you officers fail to realize that those badges and those guns don't give you the right to violate other people's rights. Sir, you are. I've articulated to you that you are illegally detaining me. And because you choose to abuse your authority and not recognize that what I'm saying is a fact, you are illegally violating my rights.
To question you, to find out if you are the one or not the one that was violating this other woman's rights.
But I've made it clear, sir, I'm not going to answer questions. I've made it clear I'm not. You don't get to. Yes, sir. The fact that I'm exercising my rights does not mean I'm not cooperating, sir.
Yes, it does.
It does not. I'm not saying I am this person. I'm not saying I am not this person. But what you fail to realize is I do not have to speak to you, sir. And that does not give you the right to detain me until you get some information to charge me with a crime. You don't get to search until I say something or you twist something I say to use it against me.
Okay, sir, back to my original question
Yes,
when
sir.
I first got here.
Yes, sir.
Okay, are you following somebody?
I don't answer questions, sir.
Okay.
Am I free to go?
Yes, you're free to go.
Thank you.
After Mr. Hoffman repeatedly refused to answer the officer's questions, they eventually ended the encounter and informed him that he was free to go. It is unclear whether Mr. Hoffman will be pursuing legal action against the officers or the sheriff's office. However, the videos on Mr. Hoffman's YouTube channel includes footage and follow-up information for several other encounters he had with the Jacksonville Sheriff's Office, including a trespassing conviction against him for an incident stemming from a First Amendment audit in 2014. So, be sure to check those out if you want more information. Overall, Mr. Hoffman gets a B, because although he demonstrated a blatant misunderstanding of the concept of reasonable suspicion, he respectfully challenged the legitimacy of the stop, verbally invoked his right to remain silent, and ultimately left the scene without providing the officers with any unnecessary information. There is no denying that Mr. Hoffman was under no legal obligation to assist the Jacksonville deputies with their investigation. However, providing a reasonable degree of information in an effort to dispel the deputies' suspicions was arguably the most productive means to end this encounter without risking a violation of rights. If Mr. Hoffman had simply informed the deputies that he was a private investigator, then any further inquiries about his conduct would have been that much more unreasonable, and he would have essentially dissolved any standing of reasonable suspicion that the deputies could have pointed to within a courtroom. It could be argued that Mr. Hoffman's decision to withhold the fact that he was a private investigator working on a case is what provided the officers with enough articulable suspicion to continue detaining him. As mentioned in the episode, members of law enforcement do not need suspicion of a particular crime in order to detain an individual, as Mr. Hoffman suggested. And what many First Amendment activists fail to understand is that the bar for achieving an acceptable degree of reasonable suspicion was intentionally set extremely low by the courts, so that officers would have a great deal of leniency to investigate potential criminal activity. The Supreme Court has said on many occasions that their interpretation of the Fourth Amendment readily accepts the notion that sometimes innocent people will be detained for appearing suspicious, and being mistakenly detained, within reason, is merely a byproduct of living within a well-policed society. This interaction highlights the notion that invoking the right to remain silent is not always a binary tool, and it can sometimes be beneficial to make an effort to dispel an officer's suspicions in certain circumstances. The Jacksonville Sheriff's deputies also get a B, because although they also demonstrated a clear misunderstanding of reasonable suspicion, the deputies were largely calm and respectful, initiated the stop based on a reasonable and credible complaint, and remained within the bounds of their authority throughout the interaction. It is clear from the video that the officers likely did have enough reasonable suspicion to detain and investigate Mr. Hoffman based on the corroborated evidence provided by the complainant. And while Florida's stop and frisk law does not explicitly grant officers the authority to demand identification from a stopped individual, it does grant them the authority to detain an individual until their identity can be ascertained. All that said, the conduct and verbiage of the Jacksonville deputies suggests that none of the deputies on the scene had a thorough understanding of how reasonable suspicion works, or how to effectuate their authority properly under the doctrine. It appears that this lack of understanding is what ultimately led to the deputies essentially giving up and leaving the scene without completing their investigation. The Jacksonville deputies could certainly benefit from revisiting the fundamental legal concepts associated with policing. But, at least for this encounter, their ignorance of the law did not result in an escalation of force or a violation of rights. Let us know if there is an interaction or legal topic you'd like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.